Please be seated. We will hear argument in 24-0024 in re UMTH.
May it please the court. Mr. Hawkins will present argument for the relators. Relators have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, for as long as corporations have existed in the state, Texas law has strictly forbidden shareholders' attempts to pursue individual redress for collective shareholder harms. A wall of authority dating back at least Massachusetts versus Davis in the 1940s emphasizes that derivative actions are the only means to recover injuries sustained by all shareholders, and creative efforts to avoid derivative suits and pursue individual recovery are destabilizing to Texas corporate law and must be stamped out. Here, Next Point has no unique and distinct personal injury. Its briefing admits that its alleged injury is the same one suffered by all shareholders pro rata. As this court recognized decades ago in the Wingate case, without a personal and individualized distinct injury, a shareholder has no direct cause of action, and the only redress for corporate mismanagement lies in a derivative action. The most straightforward way to resolve this dispute is to hold that Next Point's lack of a unique and distinct personal injury forecloses their direct action. If the court wishes to go farther, we win for a second independent reason. The fiduciary duty clause in the advisory agreement does not bestow unique and individual rights on each of UDF's tens of thousands of shareholders and authorize tens of thousands of potentially conflicting actions for individual recovery. As this court has recognized repeatedly in many cases, including Ritchie, in order to maintain a direct action, Next Point bears the burden of identifying express contractual language, displacing the normal rule that mismanagement claims are necessarily derivative, and authorizing a direct action. Next Point identifies no such language here. The phrase trust and its shareholders must be interpreted in light of the background legal principles against which the parties were drafting, including the baseline prohibition on direct actions. If the advisory agreement's fiduciary duty clause wished to displace that foundational rule, it needed to say so with clear and unmistakable language. The phrase Next Point identifies comes nowhere close to a clear statement that it's opening the door to tens of thousands of lawsuits by individual shareholders. As this court observed just 3 years ago in the Poe case, fiduciary duties to the entity and to individual shareholders are, quote, incompatible because they are, quote, conflicting. That's why the bar to show authorization of direct actions is so high, and this court should conclude easily that the fiduciary duty clause here does not clear it. The result is that Next Point lacks capacity, and the trial court had a duty to dismiss these claims before subjecting the entity and all of its shareholders to the expense and burden of litigation. Now, I've addressed the capacity argument, which is our principal argument today. I'll also address the third-party beneficiary argument that Next Point asserts. As we know from the Brummett case—
Can I ask you procedurally, what's the appropriate vehicle in the district court for you to assert this? I know you found several different instruments, but—
Yes, Mr. Chief Justice. So we filed a plea and abatement, which, as this court has held, is the proper way to attack capacity. We've also filed a plea to the jurisdiction, which goes to the standing issue. In particular, NXDT does not have standing. It's not a shareholder. NREO has standing only as to a certain time period.
But that's statutory. I mean, standing. It gets back to the question of what is standing, but is it really standing in the jurisdictional sense? I mean, I realize you don't fall within the scope of the statutory cause of action, but that seems like a reason you lose, not a reason you lack standing in the constitutional sense.
So as As Your Honor pointed out for the court in the Ritchie case, they do have an injury in fact as to the period when they were shareholders because their claim is for mismanagement, which depreciates the value of the investment and their shares in that investment. We're not saying that they lack an injury. We're just saying that if you were not a shareholder, then you don't have an injury because you don't have an investment that depreciated. And that does, I think, go to constitutional standing consistent with Ritchie.
But they do have at least one of the parties, I thought you had conceded, had held shares for a certain period of time, right?
That's correct, Justice Busby. We're not saying that no one ever has standing. We're just saying that at a minimum, the trial court should have whittled down the claims to the one shareholder from December 31st of 2021 to present. The district court did not do that and should have done so. Now, I want to be clear, the court doesn't have to get to our plea to the jurisdiction and to the standing question. The capacity argument that we're making applies to the plaintiffs entirely and requires the dismissal of all of these claims.
But it wouldn't apply to the derivative claims, right?
Well, Your Honor, they haven't brought a derivative claim. That's our whole point here. This is not a derivative action, or they have not pled it as such. They've pled it as a direct action. And I want to be clear, we are not closing the courthouse doors on anybody. They are free to pursue a derivative action in Maryland. The REIT at issue here is a Maryland entity. We know from basic corporate law that derivative claims must be pursued in the state where it's incorporated or where it's set up, and that's Maryland. And they know that. They've actually pursued actions in Maryland against the entity purportedly derivative. This is an effort to end run around that Maryland derivative action and proceed in Texas.
I was under the impression that the derivative action in Maryland has been dismissed. Are there pending derivative actions in addition to the one that was dismissed?
You're correct, Justice Bland, that their derivative action in Maryland failed. I think that may be why they're pursuing these claims in Texas. I'm not aware, I guess, of other litigation pending in Maryland that's derivative in nature. And we haven't taken a position, it's not before this court, on whether they can go and pursue a derivative action again or whatever. I think those are questions of Maryland law. All we're saying is that whatever the answer is in Maryland, there's no basis to come into Texas courts and pursue what should be a derivative action.
To the Chief's procedural question, did you also file a motion to dismiss under Texas Rule of Civil Procedure 91A and seek mandamus relief from that?
We did not, Your Honor. We filed the plea and abatement. We did so in a verified pleading, and also the plea to the jurisdiction and special exceptions.
Okay, your brief says that you filed a motion to dismiss and the Fifth Court of Appeals denied mandamus relief. Were there two trips up or just this one?
This is the one that's before the court now, Your Honor. I don't believe we filed a 91A motion to dismiss in this action. We've attacked the capacity and the lack of standing through those other procedural mechanisms. And Your Honor, we know that that is a proper basis to grant mandamus relief. The court's decision a few years ago in the Schmitz case makes clear that when you're pursuing a derivative action, if you fail at step one, you don't file the proper prerequisites to suit in a derivative action, that's a proper basis to grant mandamus relief. We think this case is a fortiori. If Schmitz teaches that mandamus is warranted for failure at step one, well, here we're at step zero. They haven't even brought a derivative action. They've only proceeded directly, and that's a basis for a mandamus relief.
So you said the lack of a unique and distinct personal injury is enough to decide this case so that we don't need to get to the language of the agreement, but would that require us to overrule Allen and Strebel? Or to disagree with those, they're Court of Appeals cases, but to disagree with those cases?
No, Justice Busby, our view is totally consistent with those cases. I mean, I think the key difference is that both of those cases involve closely held LLCs where the members of the LLC are signatories to the LLC agreement and they're suing to enforce that agreement that they're undisputably parties to and signatories to. That is very different from the corporate context, or in this case, the REIT context, where you've got an advisory agreement between the entity and a third-party advisor, and then you've got the shareholders who are not parties to that agreement by any plausible stretch, seeking to recover collective harms. If this case did involve LLCs by members suing under an agreement they were parties to, then I think we'd have to deal with those cases in more depth. But as it stands, we think that's easily enough to set those ones apart.
don't want to get bogged down in minutia, but part of me can't help it. If we were to agree with you and grant relief, would you recommend a dismissal without prejudice because of what you said about the ability to pursue derivatively in Maryland, number one? Number two, you agree that shouldn't be res judicata for any subsequent action in Maryland. And then number three, just to confirm, you don't think that there's any sort of fee trigger in play here because you're not on Rule 91?
Right, Your Honor. So I think that as to the dismissal question, we're asking the court to direct the trial court to grant our plea in abatement. I guess the idea behind a plea in abatement is you hold the case in abatement so that they can bring a derivative action. But of course, they can't do that in Texas because it's forbidden. So we think that dismissal, whether it's with prejudice or without, doesn't actually matter. They cannot proceed in the one thing that they can do here in Texas. They can try again in Maryland. We have not made any sort of res judicata argument about anything happening in Maryland. If this court were to say that these are derivative claims, not direct, we don't think that precludes any portion of a potential future Maryland action if they wanted to bring it. And I think Your Honor had a third question that I'm afraid I've lost track of.
About fees, you don't think there's any fee trigger in play here?
We have not asserted that in this proceeding. We're not asking this court to award fees. It's possible, I guess I'd want to think more about going back in district court, whether there'd be some sort of fee trigger, but we haven't presented that to this court. I believe I've covered the points I wanted to cover this morning. Unless the court has further questions, I'd reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the real party.
May it please the court, Mr. Tillotson will present argument for the real parties in interest.
Good morning, and may it please the court. I'm Jeff Tillotson here on behalf of the appellees. Just first, before I begin, a couple of clarifying points. The defendant initially filed a motion to dismiss due to a form selection clause in the UDF trust agreement, which required any action against the trust be brought in Maryland. We contended we were suing under the advisory agreement and not suing the trust. The advisory agreement has a mandatory form selection clause in Texas. That motion was denied. The Fifth Circuit Court of Appeals denied their mandamus, and they did not appeal that. They then filed this action, which is the plea to the jurisdiction, plea to the abatement and special exceptions, challenging for the first time capacity and standing with respect to it. That explains in part why we're in Texas and why we felt we had to sue in Texas for it. I do then want to begin by one point of agreement with my worthy opponent, which is that I do agree that in a series of opinions from this court dating back to 1942 in Massachusetts versus Davis, this court has been very clear. Individual cannot bring an action that is a harm to the corporation on their own basis. It must be brought as a derivative for the company.
And having said that, so what is the distinct injury that you are claiming today?
The distinct injury is a breach of fiduciary duty by the advisor that they owe to us by contract. That is the distinct injury.
But isn't that a wrong done solely to the corporation? I mean, I'm not really following.
It can be to us, it can be to the company, because the advisor takes on fiduciary duties to the company by contract and to the shareholders by contract. And so, for example, we've been trying to get books and records and information from the advisor about what they're doing, because remember, this is a company that whose executives were convicted of running a Ponzi scheme, and they won't give it to us. That is to us. Other shareholders, some moms and pops who bought into this have long since given up on their investment, but we have 1.75 million shares and it matters to us. That's direct to us. We've spent money allocating our portfolio to have this investment, which now it turns out the advisor was not being truthful and was not doing their duty. We contend that's an injury to us.
But you said it's based on your shareholdings. So to Justice Lerman's question, are your damages then associated with the reduction in the value of your shares held in the company?
So if I may add one predicate, the only way we get to fiduciary duty is by being a shareholder, and then contractually they agree, the advisor agrees they're our fiduciary. So that's why the connection you have it. It doesn't have to be reduction in value as our damages. I would contend that because this is an individual action and not a derivative action, we can allege that, and we cite at least one case, Judge Arizona in the Western District of Texas said, if you're alleging individually your rights are here, then you can go ahead and allege the reduction because it's personal to you. That said, to answer your question directly, this motion, plea and abatement, was at the pleading stage. So we have conducted no discovery at all. We have alleged in our petition that the damage of the breach of fiduciary duty is to us directly. And under this court's precedent.
Did you allege that the advisor gave your client some individual advice or separate advice than what was made available to the company as a whole?
We do not at this stage. We simply allege they breached their fiduciary duty and that breach caused us damages. Under this court's opinion in Pike, at this stage, this court has said that's enough. Maybe later on, as you do discovery, damages will then split into something you can't recover and something you can recover. But at this stage, we've done all we can because we've been denied discovery. So, for example, we suspect, but don't know for certain, that we've been treated differently by the advisor because we're the complaining party. We suspect, but we haven't been able to do discovery on, that the advisor has made moves to stymie our actions that hurt us. But at this point, all we've done is allege what we can. This court in opinion in Pike.
You haven't alleged what you just said.
No, because we don't have the discovery yet to do that. My point is that at this stage, the court has said, well, I'm not going to make you prove your damages at a plea in the abatement stage. I'm going to, if you allege that the harm is to you individually, then that's enough at this stage. And the court did that in the context in Pike and also in Ray Fisher, where parties didn't file a capacity challenge. And this court excused that by saying, well, the plaintiff told you, alleged, that his harm was individual to him. That's enough that you don't need to make a capacity challenge yet. In Fisher, they made the capacity challenge at the jury charging conference, where for the first time, the plaintiff said, here's our measure of damages. So my point in answer to your question is, at a pleading stage where we are today, I think we've pled enough, sufficiently under this court's precedent, to get past that hurdle. We think discovery will show more, but for now, we have alleged the kind of particular allegation that the harm was to us. There's also, we allege specific performance, which could be unique to us. There's the possibility of injunctive relief, that we could get an injunction to prevent the advisor from wasting assets, for example, as well as access to information that would be unique to us.
Would Maryland law give you the ability to bring a books and records claim there?
Under,
doing that here?
yes, Your Honor, under various conditions that they've stymied, we've not been able to get it in that action there. This would be from the advisor, because if the advisor is our fiduciary, they have a duty of candor and transparency to us. So they couldn't tell you, we're your fiduciary, but we're not going to tell you what's going on with the company that you have an interest in. And so that's why this action is unique to us and why it is different from it. You cannot get the relief I'm seeking in this case in Maryland, because if you say all we can do is bring an action against the company, the advisor is out. What then do I do? And if I sue the advisor in Maryland, the first thing they're going to say is, you can't sue us. We have a mandatory venue clause in Texas. And so we have to have two actions. There's no way around it.
Well, ordinarily, and is this company it's still an ongoing company?
It is.
Okay. So ordinarily, a shareholder of a company that's continuing and not in bankruptcy or something like that, the appropriate thing to do would be to request an inspection of the books and records from the company. And then if that demand was refused, then go to court and seek relief there. But this seems like we're not there, because that should be over in Maryland. If the question is books and records.
That has happened in Maryland, and we brought that action. It was dismissed due to failure to make demands under Maryland law. We have a coexisting right with the advisor who has an agreement where they've said they're our fiduciary, which would require them to have a duty of candor to us till we get that information. Simply because we have two avenues to obtain those rights does not mean that we can only take the route towards the company. This situation, I mean, the reason we're here is not something we did. It is the fact that UDF structured their affairs this way. As the briefing makes clear, what UDF does is they're a real estate investment trust, no employees. They raise money by issuing shares. They have the ability to download all their obligations, duties and obligations to an advisor, and then that advisor then runs it. Now, typically, as a shareholder, that's dangerous because someone else is running the company and you have no ability to do that. Under various case laws, investment managers have no fiduciary duty to the investors. What UDF did here, and some do it and some don't, was don't worry. The advisor is in a fiduciary capacity to the company and to you shareholders.
And on that, which your whole argument is based upon that
Yes.
point, you're referring just to the advisory agreements statement, it's the fiduciary duty to the trust and its shareholders, is that
Correct.
the whole thing
Yes.
for it? And so if that part turns out to be wrong, if we read that as to the shareholders collectively, it's understood in the long context of corporate law, then does everything else topple with it, or is there anything else?
If my client's not in a fiduciary relationship under that provision, we allege nothing else. Because we recognize that, as court has said, that although you have said you can't bring an individual action, I can't bring an action for the company, you can bring an individual action if the right arises by contract or law. Every opinion you've issued has had that language right under the language opposing counsel just cited. And you've also counseled, and I encourage the court to consider this, in Ritchie, when you said there's no minority shareholder oppression, in the estate of Poe, where you said you can't serve two masters with an informal fiduciary duty and a duty to the company, you've also counseled shareholders, if you want protection, because the law may not protect you as a minority shareholder, get it in your shareholder agreements. And that's what happened here, only it happened in the advisor agreement.
Yeah, but this is not a shareholder agreement. You conceded that much at least.
It's the advisor agreement between the company and its advisor that says the advisor agrees they'll be in a fiduciary relationship to us.
Right, but shareholder agreements are obligations that individual shareholders undertake to each other, and they're signatories to the agreement, right?
Yes.
Okay, so we're talking about a different kind of agreement here.
We are, but the effect of the agreement is what you can structure your affairs any way. Here, there's a trust agreement that puts all the power in the trust and gives it the ability to download that. And there's an advisor agreement, and you know this going into it as you become an investor because that's how they've structured their affairs. So it's fair for a shareholder like us to say our bundle of rights to protect ourselves, if you will, is both the advisor agreement and the trust agreement. And the reason why is the advisor does everything. The danger here is what happens if the advisor, as we allege, and I think has been proven in federal court with the criminal convictions of these folks, the advisors were in cahoots with the trustees.
But presumably those people that have been found guilty of wrongdoing to the company are no longer in charge of the company, which you say is a continuing business.
It's not part of the record, but unfortunately that's not true because their ownership is still there. They're the dominant owners of the advisor, and they're also dominant owners of the entities that control it. And so that's one reason we're fighting, because in our mind, the fraudulent conduct has not been rooted out of the company. And the mechanism by which we have to fight is the advisor, because the advisor is doing everything. The advisor runs the company. They make the investment decisions, they decide the distributions, they decide what information to publicly disclose. So when we buy these shares,
There is a board of directors that you can make a demand upon.
yeah, there was trustees, because it's a trust, but
Trustee,
absolutely,
sorry.
yes, Your Honor.
Yeah,
No,
State Investment Trust.
yes.
Yeah, okay. A board of trustees that you can make a demand.
There is, but this court has said in numerous opinions, Wingate, Ritchie, if you have an individual right, you can enforce that. You don't have to go the derivative route, which is more complicated, more difficult. Also, you got to make a demand, and what if they say no? And then you have litigation over that alone. You can pursue your individual rights, and that's what we have. And because those rights are with the party that's actually running the company, it makes most efficient sense for us to do it in that manner. I recognize the temptation is to say you're going to unleash litigation for companies, but this is a unique situation, which I think we argue, which you've not been presented with before, to my knowledge, which is someone shows up here in this position and says, My rights come from a contract that makes me the beneficiary of that fiduciary duty. Everyone who's come before you has said, impose an informal fiduciary duty on these folks. Because he was my dad, like in Poe, and he was supposed to trust me. Or in Ritchie, I'm a minority shareholder and the majorities are hurting us. Please impose that informal fiduciary duty. We are not asking that. We recognize the court has said we're not going to do that because of the conflicting nature. But here, we have exactly what this court has been saying for years is the only way to bring that suit, an individual right. Sure, it's in the advisory agreement. But remember, this is the right they gave us. And for them now to turn around and say, how dare you exercise that right? This would contravene corporate law. This court will have to undo 80 years of precedent, which says, we got it wrong. You can't sue a company, even if you have that individual right, if you can sue the company anyway.
Unless we read the advisory agreement differently than you read it, and instead read it to impose the danger on each of these shareholders that somebody could come to court and say, we need to do discovery. We don't know what the specialized, individualized breach was, but we'll tell you later, but for now you're gonna have to pay to litigate it. And you think that's what everybody agreed to when they said fiduciary relationship to the trust and its shareholders, and each and every one of its shareholders individually.
I would disagree slightly with the premise, Your Honor, I mean, respectfully, which is that I think we've alleged what we believe the advisor did wrong through exclusive pleadings. We've detailed all of the actions, some of which came out in the criminal trial. So we've alleged what they've done wrong. We have not alleged specific dollar damage at this stage, but we have alleged individualized harm to us with respect to it. And yes, I don't know why the advisor would agree to a fiduciary duty to the shareholders, including my client, but then not expect to be held to that, not expect to be held accountable if they breach that duty. And yes, the way out of this is to simply say the language that the advisor is in a fiduciary duty to the company and the shareholders actually doesn't give the shareholders any rights they didn't already have as shareholders in the company. You could read that out, but then this court would have to put a footnote for its opinions which said give the plain, ordinary meaning to the language and give effect to every provision, except when it comes to companies with respect to derivative. Then you don't have to do that.
The notion that the fiduciary duty would be owed to both the company and then also to each shareholder individually is just unworkable. I mean, as soon as there's any kind of disagreement, then you can't owe a fiduciary duty to advance the interests of all of those people, all of those entities separately.
So, Your Honor, I agree, and this court has mentioned in Ritchie, Poe, and Wingate, there's that tension if we impose an informal fiduciary duty on an officer with respect to a particular shareholder. Here, that tension was agreed to by the advisor, number one, but number two, 99% of the time it won't matter. Why? Because if you are an advisor trying to run the company according to your fiduciary duties, you'll be fulfilling those duties to the shareholders as well. It arose here as a conflict because we contended the advisor said, who cares about the shareholders? I'm going to benefit the trustees because I am the trustees. And so you have that conflict, but only because what they did was improper. But many, many parties accept multiple obligations and deal with those issues. And a true advisor in a fiduciary capacity who says, I think what the shareholders want is not what the trustees want, and there's a conflict, would raise that duty of candor and potentially say, I can't be the advisor under this basis. So the shareholders would have some ability to deal with that. That didn't happen here because the advisor and the trustees are the same people.
Doesn't that suggest that we shouldn't read the agreement that way? That if it came to pass that the advisor would immediately have to resign and nobody is running this trust because you can't serve two masters, that we ought not to read it that way?
Well, I think you can serve two masters under circumstances, and they do it all the time. I mean, an officer of a company has a duty to the company, but if they have shareholders, they're thinking about the shareholders, okay? And you do have conflicts. I'll give you a simple example. The president of a company who has a fiduciary duty to the company has bonuses that incentivize short-term performance, whereas shareholders think long-term performance is better. You have that conflict. Shareholders lose in that situation, basically, because he has a duty to the company under this court for it, and no one raises a big issue about that. But what happens if the president says to the shareholders, I will protect you, I promise I'll be a fiduciary to you as well as the company. He's now obligated to blend those two views and take the best route for them.
But the problem is you collectively said the shareholders all agree that long-term performance is their preferred strategy. And we all know that shareholders don't agree about that. And you could have Elliott as a shareholder or someone like that. And short-term is their goal. So that, I think, is the problem, is that there's not a collective view of the appropriate management.
Right. Or God forbid, my client is your shareholder, who is looking for some issue, and not all shareholders do agree. Some shareholders in this company, many of them are what we call mom and pop investors that don't really have the ability to do it. That, however, Your Honor, I would suggest.
Did your client, or did NREO take these shares after all of this had blown up?
Well,
or before, and was there any decline in the value of the shares after the transfer of after the transfer of the most of these shares to NREO?
The answer is yes. What happened?
Had blown up already.
Yeah, no, it had blown up, but there was continued poor performance thereafter that date of December 31st.
So the shares continued to
Yeah,
decline.
and to clarify this, the quote unquote, the standing issue, and I agree, I don't think this is necessarily jurisdictional, it's the ownership of the shares, but the original plaintiff bought and owned the shares. They then themselves became a REIT and had to divest ownership of the shares as the record holder, but not as the beneficial holder. They then transferred them to a wholly owned subsidiary and affiliate that they control, who is now the record holder. So you have record holder here, but ownership by this record holder in full of that entity. And under the statute for derivative claims, which I don't know applies here because we say we're not, nonetheless, you can have it in that nominee capacity. And this court in Snead versus Weber has expanded it to say beneficial owners have that standing. So I think the stock ownership issue is a non-issue for it, with it. And so just finally to answer your question, shareholders don't agree, but when this advisor took on the responsibility, it agreed to deal and navigate with that. And I'd ask this court not to let the advisor out of this particular issue. My time has expired. Thank you very much.
Any further questions? Thank you, Mr. Tillotson.
Thank you, Mr. Chief Justice.
Mr. Hawkins?
Thank you, Mr. Chief Justice. Just a point of clarification to Justice Sullivan. I misunderstood your question earlier, for which I apologize. There was a motion to dismiss in connection with a different forum-related issue. That's not an issue now before this court. As to the issues before this court, the capacity and the jurisdiction, that was not the subject of a 91A.
My question probably wasn't that clear, sorry.
Not at all, Your Honor. I think Mr. Tillotson made a number of points that are worth emphasizing. Number one, I think he's admitted that he fails the Thule test. This is the iconic Delaware test for whether a claim is derivative or direct. The test there is, can you show an injury to your client without also showing an injury to the entity? I think he just said the answer is no. I think it was Justice Lehrman asked him directly, what is your distinct injury? He said, well, it's a breach of fiduciary duty. That's not an injury.
Is the failure to provide books and records distinct?
To the individual shareholders, I don't believe so.
Well, presumably the company has the records, right?
It's a right, though, that would be redressable by all shareholders equally. If a company is not giving up books and records when shareholders demand, that's something that everybody suffers from. I think when we're getting to distinct injury, I think a helpful case to illustrate this is the Linegar case, which shows how this could work, having dueling agreements and distinct injuries. In that case, you've got an individual, an entity, and a lawyer. The individual and the lawyer have an attorney-client relationship that comes with a number of duties owed by the lawyer to the individual. That lawyer is also advising the entity. The lawyer advises the entity in a way that helps the entity and makes the entity better off, but harms the individual. What Linegar says, what this court said in Linegar 10 years ago, is that the individual does have a claim then against the lawyer for breaching that separate attorney-client relationship that caused him a unique and distinct harm. That case passes the Thule test because there is no injury to the entity. The entity is better off because of the advice the lawyer gave. That's the situation that we're looking for under these cases, and it's entirely different from what we have here, where we've got the third-party advisor and the entity, and the shareholder's injury is literally derivative, as I think Mr. Tillotson notes.
What is your response to the idea that the individual injury aspect it's premature to dismiss the suit on that before discovery can be had.
Your Honor, I don't think discovery is going to tell us anything we don't already know. The nature of these claims is derivative. We look to the gravamen of the complaint, not to the way it's pleaded. Mr. Tillotson says he'd like discovery. Well, it's not going to matter whether his damages are $10 or $10 million or $10 billion. What matters is this the type of injury that is unique and distinct? And there's nothing in discovery that's going to prove anything about that. And I don't think I heard him identify anything he would find out in discovery that would suggest that these are distinct injuries apart from the injuries suffered by the corporation. And Justice Bland, you don't have to take my word for it. Their complaint effectively admits this. It repeats repeatedly that the injury is to UDF4 and its shareholders, and that's a concession that this is really derivative.
He says that they suspect but have not yet alleged, because of the lack of discovery, that there may have been adverse treatment uniquely directed to them. How do we respond to that?
They have not alleged that. We're at the first amended petition stage in the complaint. There's no allegation of that. I don't think the court needs to credit that.
The point, though, is that he says we haven't had discovery. Justice Bland just asked you about, well, at this stage, is it premature? And you said there's nothing that discovery could show. And he said it could show what we suspect. And if we can find something through that, then we can amend our petition.
I believe, Justice Young, this court never allows plaintiffs to make the argument, I need discovery so I can find out what claims I have.
But
well,
isn't
that may be right, but what is it? I just want to make sure I understand. You said there's nothing discovery could show. And that's a different point. It may well be that he's not entitled to for some reason, but is he wrong? Is it true that discovery could not show any individualized injury, assuming, of course, that the reading of the advisory agreement is correct, that there is a distinct fiduciary duty to them? Is that right or not?
I don't see how that could be correct, that discovery could provide anything that would inform whether this is direct or derivative. And as this court's case has recognized, the question of direct versus derivative is a question of law that goes to capacity, and this is all pre-suit stuff before we get into discovery and can and should be decided as a matter of law.
But there are multiple claims here. I believe your opposing counsel said there's a claim for injunctive relief and specific performance seeking unique information. And so should we treat those claims separately and say, well, they get the information, and then once they have that, then maybe they can or can't allege the other claims? It seems like there's sort of an order of operations here.
Well, Your Honor, they've asserted 4 claims. The primary ones are breach of fiduciary duty, breach of contract, and then aiding and abetting and conspiracy. These are all derivative in nature. At the end of the day, we know under Wingate they need, number 1, a cause of action, and number 2, a distinct personal injury. And their complaint shows that they can't satisfy either one of those prongs, and they haven't identified what in discovery would change the outcome for that. I do think it bears some emphasis. I think the Chief Justice Blacklock and Justice Bland were exactly right about the conflicts of interest that their view would create and the disorder that would wreak on Texas corporate law. It's very easy to imagine you've got some shareholders who want a conservative, low-growth strategy. You've got other shareholders who want an aggressive and risky strategy. And it's easy to imagine that those views would be conflicting, as Poe itself recognizes. Well, under their view, they all get to file individual claims under this agreement, and they all get discovery that's incredibly burdensome on the entity. It depletes the resources of other shareholders who've invested in the entity, which is why the court repeatedly rejects efforts to do that.
But to even know which one it is, you have to be able to look at the records, right? To even know if it's a derivative claim or an individual claim.
Well, Your Honor, I think we can figure out whether it's a derivative or an individual claim, in this case, based on the complaint, based on the type of injury they're alleging, and their basis for asserting a cause of action. I mean, I think it's worth noting that their basis for claiming the cause of action is that language in the advisory agreement. And I'm happy to get into why they fail at step 0 there, why that language does not bestow individual rights on them. Simply put, they failed the clear statement rule that comes from this
No, I understand your argument on that. I'm just trying to figure out when you've got a setup like this where their agreement says you have to sue in Texas and you're saying they have to sue in Maryland. It seems like, what should they have done to try to get information about whether the people who've been criminally convicted are still running the advisory firm and whether they've been discriminated against?
Your Honor, this contract can absolutely be the subject of a lawsuit in Texas by the parties to the contract. They are not a party to this contract. They're not a third-party beneficiary. They say that's unfair. They should be able to sue, but this court does not allow third parties, strangers to a contract, to sue to enforce the terms of that contract. I think that's why that argument fails, Your Honor. Just one or two additional notes. The Ritchie case I heard Mr. Tillotson address, that case expressly refuses to recognize a cause of action for minority shareholder oppression precisely because the injuries asserted in that case are not cognizable directly. They are derivative, and that's exactly the injuries that are being asserted here. That's page 887 and 888 of Ritchie. And Ritchie itself recognizes that the existing protections for shareholders are adequate. And there's no reason to reach a different conclusion in this case.
So if they're right that the people running the advisory firm and the people running the trust are all the same people and there's a conflict of interest, you would say that's a derivative claim and they should bring that in Maryland.
Your Honor, that is absolutely...
Because there's a conflict of interest, which is a breach of fiduciary duty.
Your Honor, that is a prototypical derivative claim. I think derivative actions along those lines are filed every day. I see that my red light is on. Unless the court has further questions, we would ask that mandamus relief be granted.
Any further questions? Thank you, Mr. Hawkins. Thank you to all counsel. The case is submitted, and the court will take another brief recess.
All rise.